I'm going to just give some overview of the basic aspects, furlough versus layoff. Ben will be talking about unemployment issues and the WARN Act implications. And then Scott will talk about some of the PPP loan and other federal law CARES Act implications. So first, to clear up what's been some confusing language for folks is the difference between furlough and layoff. And there isn't necessarily a difference. There's no legal definition that defines either one. But generally, when we talk about furloughs, we mean a temporary layoff, whereas if it's a layoff, you mean a more permanent layoff. Those are loosely used terms. You will hear people use both of those terms at the same for meaning the same thing. But in terms of furlough, there are some differences that are important to note. Is that because a furlough typically refers to a temporary leave of absence, the employees are expected to return to work after a furlough. They're expected that they could be called back at any time during a furlough. And you can, in most circumstances, continue providing health insurance benefits during a furlough versus you couldn't do so during after a permanent layoff, because that's considered a termination, whereas a furlough is temporary. So it's an impact on benefits, and it may impact unemployment. Previously, the Vermont Department of Labor would not have allowed unemployment benefits during a furlough. But this whole COVID situation has, as I'm sure you know, caused a lot of upheaval in everyone's lives, but certainly at the Department of Labor. The Department of Labor has tried to implement policies to help workers along the way, so that furloughed employees are still entitled to unemployment if they otherwise meet the conditions, even though they may be continuing to receive health insurance benefits during that time. So that's a change from the normal law during this COVID period. So layoff, as I mentioned, is generally considered a permanent separation due to lack of work. And the difference with layoff versus furlough here is that a layoff, which is considered permanent, would trigger COBRA. COBRA is the federal law that requires you to give notice to employees about their rights, and it gives them the right to continue their insurance, their health insurance benefits for a period of time after they leave under the same policy and for the same amount of money, although generally they are responsible for paying that premium. One thing to keep in mind, that if you are furloughing or laying off employees, that if you have exempt employees who are not paid hourly but are paid a salary and who meet the definition of being exempt under the Fair Labor Standards Act, so they're either executives in that they manage people, or they're administrative in that they are in charge of the operations of a division, or if they're a professional, those exempt employees must be paid for the full week of salary in which they're furloughed or laid off, even if they only work part of that week. For hourly employees, of course, you only have to pay through the time that they actually worked. So who will be let go is a question. Now, I'm sure that you folks in the hospitality restaurant business have already made a lot of these decisions. And you may be at the point of saying, who's coming back? How do we decide who's coming back, or who do we want to come back, and who do we not want to come back, and or we want people to come back and they are not willing to come back. So those are all scenarios that are happening as we speak for a lot of different employers. So I think the thing that's important to think about when you're either calling people back or laying people off is making sure that you are doing so in a non-discriminatory manner. So I think you can establish criteria for deciding which employees will be let go. For instance, you may have decided that you have too many wait staff, or you have too many of one particular area, and you decide to let people go. It's okay to establish criteria according to the job function, but you do have to be careful about disparate impact. You don't suddenly want to say, okay, we're going to let everyone go who's over a certain age, or we're going to let everyone go who's has a family, or we're going to let anyone go who's pregnant, or we're going to let anyone, because all of those issues can implicate discriminatory actions that you certainly want to avoid. And you should document how you decide who gets to go or who gets to stay, or who you call back versus who you don't. And I think that the thing here to keep in mind is, as long as you have legitimate reasons, for instance, you have a job category, or you have a business need because of reduced service needs, but it's just based on how, I need 3 waitstaff people and 2 back of house people, then that's okay if it's that sort of criteria that doesn't belong to a protected category, such as gender, age, religion, and all the other categories that are protected under law. The issues about layoff, if you're going to decide, we just don't need that many people, we're going to lay everyone else off. COBRA is implicated, as I mentioned, so you have to give notices, and people are entitled to continue health insurance if they have it. You have to be cognizant of PTO payout. You don't necessarily have to pay PTO out if someone's on a temporary furlough, but if you're terminating someone in a more permanent layoff, then you're going to have to pay. If you have a policy that requires that the PTO is paid out, you're going to have to make that payout. You probably don't have anyone that has employment contracts or unionized employees, so you don't have to worry about contracts. But if you do have such employees, then you need to look at the contracts, because the contract will govern what you need to do. A notice of termination is generally a recommended step to take. And then you can think about, do we want to use severance agreements? And in some circumstances, if you know that you're never going to want this person back, or you're changing the way you do your business, there are some employers in your industry that are considering severance agreements, and written severance agreements where you pay someone some money, and in exchange they sign a general release that releases you, the employer, from any liability in connection with their employment. And there are a number of circumstances when that can be useful, particularly if you have a situation where employees have potentially raised some issue, or if they're a member of a protected class and you're concerned about something, then you should consider and speak with legal counsel about a potential severance agreement where you pay money to someone in exchange for signing a release. And when you do that sort of thing under a layoff, if there's more than one person that you're laying off, then you have to consider the ramifications of that under the Older Workers Benefit Protection Act. And this only comes into play if you're actually paying a severance and asking for a release. If you're getting a release from liability from an employee, then you do have to consider the Older Workers Benefit Protection Act, which I'll talk about in a minute. Of course, there could be alternatives to layoffs, and some employers, and I'm sure you're using some of these tactics already, but reducing hours and reducing compensation, flex time, compressed work week, or job sharing. Sometimes those are workable. It depends on your workplace and what the job is. But certainly those are alternatives that can make your money go further under these uncertain times, or at least in these interim times as you begin to reopen. So if you're considering a permanent layoff, you can think about a voluntary plan first before you go to a mandatory severance situation. But keep in mind that if it's voluntary, you get what you offer in terms of if anyone volunteers, you have to accept that, and you can only offer it to some and not others based on any category, protected category. So for instance, you could say, we're going to offer a voluntary leave or voluntary termination program, a voluntary severance program for people who have worked for us for 20 years. And you include everyone in that. Or you could say everyone in our marketing department will be offered a a voluntary severance. So you want to pick a category that makes sense rather than individuals necessarily. And if you're going to pick individuals, you have to be careful about that. And anyone who volunteers, you have to accept. You can't say, no, 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 I don't want you to leave because you're too good. I want that other person to leave because they're not so good. Can't do that. Once you make that voluntary offer to individual employees, then you've got to accept whoever volunteers to be laid off. If you are going to go with an involuntary severance, as I mentioned before, there are certain circumstances where when that's beneficial, if there are particular issues with employees, and you would pay some money in exchange for a release. You can't have a release without giving that employee something of value. The release is not effective unless that employee receives something of value. And so if you're going to do that, and there are circumstances when it's helpful, then you do have to think about very specific criteria, and you should again check with counsel because these are very specific circumstances. But there are things that you need to do. And if you're laying off 2 or more on a permanent basis, under the Age Discrimination and Employment Act, you have to do a number of things. And you have to provide, one of those things is you have to provide the titles and the ages of all the people who are eligible for the layoff and all of the people who were considered but not eligible for the layoff. So you essentially have to give the ages of everyone was considered in order for that person who's signing the release to make an informed decision about whether or not the actions that you're taking are legitimate and whether or not they have an age claim. And so it's considered an informed release of their waiver of their rights, but it is essentially giving them the information they need to make that decision. But it's not to be done lightly by the employer. It should be done with counsel because there are some traps for the unwary when you go through that. You also must give 2 or more people who are being laid off under a severance agreement 45 days to consider whether to sign it. And so essentially the offer to pay them remains open for 45 days. Assuming they agree during that time, they can agree sooner rather than later. But once they sign, they have 7 days to revoke their agreement. So we generally advise that nothing be paid to the employee until that 7-day revocation period ends. And then you make the payment to the employee, and you, the employer, have the signed waiver so that you can rest assured that that person is not going to sue you down the road. So all of these considerations have to do with potential discrimination claims being brought against the employer, and that's the consideration here when you're worried about letting people go, particularly if you're picking out individuals. And if you're picking out individuals based on performance reasons, and we know that happens, it's important to have the performance issue documented in some way so that you have that prior to the decision to terminate. So that's a very quick run through of kind of some general considerations in layoffs and severance. And I'm happy to take any questions before we turn it over to Ben.
Thank you, Beth. Right now, I don't see any questions.
Okay.
So we'll move ahead, but thank you for the reminder, Beth. I encourage attendees, if they have questions, to use the question and answer button at the bottom of your screen, and we'll try to answer them as we go along. So I'm going to turn it over to Ben.
Okay, Ben.
Thanks, Walter. As folks mentioned, my name's Ben Travers. I'm an associate attorney with our labor and employment group based in Burlington. Beth and I and our employment group have been busy these past few weeks for all the wrong reasons, having to help employers in all industries deal with some of the toughest decisions in both their business and personal lives. And I know that the last few months have hit the hospitality industry particularly hard. Personally, I've been following and was happy to sign on to your Don't 86 Us petition, and my family has otherwise tried to make an effort throughout all this nonsense to regularly get takeout and delivery from local establishments, and I'm excited to see that many of you have been able to open back up a bit here. But I also, of course, recognize that you've had to let people go or furlough people or whatever the term you may use, as Beth just went over, and that others may be considering having to let even further people go here in the future. So some additional considerations to consider on top of what Beth just mentioned. The first I'll go through very quickly, and the reason why I'll go over it is because it might apply to a couple of you, or if you have been Googling or looking at other resources as to what you need to consider in going through layoffs, one of the things that may come up is referred to as the WARN Act. The reason why I say it may only apply to a couple of you is that it's a federal law that only applies to employers of 100 or more employees. I think there's only 100 or so employers in the state of Vermont with 100 or more employees, but nonetheless, this is just a brief primer with respect to what it is. The WARN Act, from the federal law standpoint, requires that employers give 60 days notice of a plant closing, which would basically, you know, it's termed in sort of manufacturing plant factory, but that term plant would apply to a restaurant or to a hotel or to a bar or really any single establishment, or a mass layoff. And it requires that notice